they can as well have free consultation, apart from, of course, ensuring that particular field they get good expert advice. But that was on the lighter vein. But the fact is that I find that many promoters are doing that, try to identify people from different fields which would be relevant to you, to that company, and then you have opinion of different people, different expertise available within one room where a good interaction can take place. And this I find 2-3 companies where I am there 80% of the directors are independent directors. Only 20%, and in one case, till recently it was only one promoter director was there as a managing director, rest the chairman and another 7-8 independent directors completely. And they are so happy because they believe they are getting so much advantage from the expertise and experience of people from different fields at one go. And there I feel that promoters can really take advantage also. If you identify right people and have a proper mandate and you are a forward-looking management, you have everything to gain and nothing to lose. But in the transition, it's not going to be easy, because the problem is arising for companies who are very well off. Everybody wants to be independent director on those boards. Companies who are in trouble and need more help of independent directors, nobody would like to join them. So for some time this kind of issue is going to be there. Let's see how it pans out. Now, SEBI has again prescribed a person shall not serve as independent director on more than 7 listed companies. And if he is a whole-time director in a particular company, any listed company cannot serve as independent director of more than 3 companies. Of course, the idea is very clear, because the more the companies you are on the board of, less you are able to devote time. The olden days where you could be director of so many companies, where private companies were not counted, Section 25 companies were not counted, are all gone. And today, the directors have to devote time to the companies where they are on the board, whether as independent director or otherwise. So, a person taking or accepting independent directorship has to restrict to 7. If it is more than 7, when this provision will come into force. So far as SEBI change in clause 49 is concerned, it will be effective from 1st October 2014. That is the only wise thing SEBI has done, that it has given a lead time, unlike Companies Act, where on 2nd April they say it has become effective from 29th March, which nobody knew. And even the Bombay High Court had to pass observation in the matter of Godrej, where it was in the context of a merger petition. They were seeking exemption from a meeting, and there the court observed that one sheet of paper, these are the words of the court, on which number of sections is mentioned, one officer from MC has signed, and he said these sections will become effective, and there is no notification about any of those sections. Believe me, for 2 days even I was searching, and when this thing came up, trying to locate, talk to people in Delhi, everybody said it is effective. Nobody could talk about notification. And then the judge remarked, notification is not for fun. There is a legal purpose behind. How can the ministry just ask anybody to sign and say sections will become effective? Now, this was just before the vacation, and the court directed notice to be served on MCA as well as SEBI, so that this matter can be considered in detail, because they said it's not only relevant to the petition before it, but relevant to all the companies, and in future all these issues are going to arise, and therefore court is going to take a view on this particular issue. So in that context, we are going to see some more developments happening. Now, who is responsible, whether a person is an independent director or not? that responsibility has been put on the individual himself or herself. Normally, in practice, what will happen will be the company secretary will send a declaration format to the concerned director, asking that concerned director to sign the declaration. So it is for the individual, because company will know only to the extent the director discloses. But it is for the individual to satisfy himself or herself that he or she meets all the criteria which are laid down for a person to be qualified to become an independent director. This is an annual declaration at the first meeting to be given, or whenever one joins the board, then immediately at the first board meeting after appointment as independent director. Now, government proposes to encourage data banks to come up so that they will provide ready data of independent directors, persons who want to become or volunteer themselves to be independent directors. Perhaps chambers of commerce, professional bodies like CA Institute, Company Secretaries Institute, any other agencies, even private agencies, could be permitted to have data bank for selection of independent directors. But again here, one point that has to be noted is, although you may use the data bank of any organization, the responsibility is not of that organization. The responsibility will be of the company accepting somebody as an independent director, so that tomorrow if there are some issues there, you cannot turn around and say, so and so chamber had given us the name, or so and so company had given the name. They are only providing certain names subject to clearance by the company itself. And as we know, in this country, so many things happen, including bogus declarations and bogus certificates. And when you are taking somebody from some data bank who will vouch for the veracity of that person for the certificates given by him, that could be a major issue. Because recently I came across, I happen to be a director on a company, listed company, which has taken over a company which specializes in doing background checks of various category of people in different organizations. And there they have found, and across the board, not just in one particular industry, various industries, lot of bogus certificates being provided. Certificates in respect of experience, certificates in respect of qualifications, certificates in respect of remuneration, and so many other things have been there. So when you will be taking from data bank, any company which takes will have to satisfy itself. And here it will be more important, because not merely the qualification of other things. He is going to be a part of the board. Whether he is from the being supported by some competitor or he being planted by some competitor, he may be, his papers may indicate excellent background, he may be genuinely having an excellent background. But whether he will be asset to you or later on the time will indicate he turns out to be a liability. That is going to be because commercial espionage is one of the biggest growing areas. Today, that's why companies, particularly those who are in development of products, new research, you never know from where somebody is trying to gather data or information, or IT companies. Today, data is power. So, there is every possibility. Now, that factor cannot be discounted, and therefore, this due diligence is going to be a very important factor for a company to satisfy itself that not only the paper work is in order, that whatever that person gives is A-class right, but whether that person will be an asset or a potential liability also will have to be assessed by the management. Now we come down to the term of office for independent director. Under the Companies Act, it's very simple, up to 5 consecutive years. and not more than 2 consecutive terms. First term, ordinarily straight away up to 5 years that is possible. Second term, when you have to appoint, you have to pass a special resolution. It will not be an ordinary resolution. Now, here we find it interesting so far as SEBI is concerned. Companies Act says that whatever term the person has already spent on the board, maximum is 2 terms of 5 years means 10 years, but the person could have been on the board for already 20 years. That you have to ignore. And you can give a fresh term of 5 plus 5. SEBI says if you have already exceeded the term, more than 5 years you have been on the board, so we take for the simplicity, somebody has been on the board for 10 years, independent director, then SEBI says whatever balance remaining term you have, and in the normal course that will come to an end, plus 1 term of 5 years. But that term, recognition will be from 1st October it starts, which means most of the companies would have completed their AGM by 30th of September. So all the companies are going for appointment of independent directors at the AGM, effective from 1st April 2014, when the Act became effective, for a period of 5 years, running from 1st April, which means effectively they all will be having 4.5 years by virtue of the fresh appointment they are doing, because the rule will become effective that as on 1st October, whatever balance period is remaining, and that in the normal course will come to an end, then 1 term of 5 more years as per SEBI regulation will be possible. Whereas as per Companies Act, straight away 5 plus special resolution 5. Now there has been slight confusion where people are asking that somebody has already completed 5 years or 10 years or whatever. Then we appoint a person because we are taking a new person from outside. For example, we are talking about data bank, and you don't know how he turns up. And if we take him straight away for 5 years fixed term, so why not we take him for 1 year or 2 years, and then again we find him good for another 3 years, and then balance 5 years later. Is that possible? The simple answer is no. Because here, the crucial words you should note are, in the first line you read, it is up to 5 years. And when it says up to 5 years, and there are 2 terms, you choose once, the term is over. If you have chosen up to 2 years, then that term gets over instead of 5 years after 2 years. If you choose 3 years, 3 years you choose 4 years. You cannot have 2 plus 3 or 2 plus 2 plus 1 or anything, or no. Only 1 term, initial up to 5 years or lesser, whatever you decide, plus maximum 1 term up to 5 years if it is under the Companies Act by passing a special resolution. So that should be very clear that splitting the term is not going to help you. It will decide the lower period, then it gets closed at the lower period. Now once the 10-year period is over, or whatever maximum permitted, then in that case again there is a cooling period of 3 years if you want the same person to come back on the board as independent director. So like the earlier provisions, here also 3-year cooling period is provided, and again the same person can be appointed, because here the belief is, and that was one of the factors which was being discussed, that when a person has been on the board for a long time, then it tends to become very close to the management, and to an extent the independence could get compromised without even realizing, which to an extent may not be totally out of place. It can happen that one tends to become much more friendly and may start overlooking certain things without realizing also that he or she is overlooking that. So that is why perhaps this break is necessary to come back. And that's why it's mentioned that during those 3 years, no relationship with the company, so far as pecuniary is concerned, either directly or indirectly in any capacity whatsoever, so that the person should not be indebted or obliged to that company also in any manner. Now this is interesting that for independent directors, for the first time, a code has been provided by way of a separate schedule, guidelines of professional conduct. Now I'll just read out some of the important aspects so that you have a better understanding about the whole thing. These are the headings which I have provided here. Under each heading, certain aspects have been given. For example, guidelines of professional conduct. An independent director shall uphold ethical standards of integrity and probity. Act objectively and constructively while exercising his duties. Exercise his responsibilities in a bona fide manner in the interest of the company. Devote sufficient time and attention to his professional obligations for informed and balanced decision making. Now, this is very important. There have been directors and directors who have been on the boards but not able to attend meetings. I have come across in my career many times. I have seen that whole year, which now, as you will know, under the new act, that is not possible. One meeting has to be attended. It is not enough to say that with leave of absence. One meeting has to be attended. So now the law itself provides, and part of the code of conduct, that adequate time has to be given for the company's work as independent director. Refrain from any action that would lead to loss of his independence. Now, that onus again is on the individual, that he should not do any such thing which could compromise his independence. Assist the company in implementing the best corporate governance practice. Now, roles and functions. What is expected of an independent director? Help in bringing independent judgment, bring an objective view in the evaluation of performance, scrutinize the performance of the management. Independent directors have to scrutinize the performance of management in meeting agreed goals, satisfy themselves on the integrity of the financial information. One important thing we all need to remember, and which I would like to stress upon, that really speaking, the whole structure of corporate governance is dependent, as far as the scheme of law goes, on the role of independent directors. It is expected that they are going to be playing a very proactive role to ensure that company managements are really on the right path. To what extent that will succeed is a separate issue, for the simple reason that, like any other ordinary director, independent director doesn't spend extra time in the company. He doesn't have a chamber to sit in the company there. He doesn't look into day-to-day records of the company. But the kind of expectations which are there from this creature called independent director, and the code which it talks about at one stage is kind of frightening, that whether they are expecting some super human beings to be there on the board who come for quarterly meetings but at the same time know exactly what is happening in the company from day to day virtually. Because particularly satisfy themselves on the integrity of financial information, financial controls, system of risk management, etc. Safeguard the interest of all the stakeholders. Today it is not merely shareholder, but all the stakeholders. That is also the responsibility of independent directors, and interestingly balance the conflicting interests of various stakeholders. That also independent directors have to ensure the balancing act between different stakeholders. Then what are the broad duties? This was the role and function. What are the broad duties? Undertake appropriate induction and regularly update and refresh their skills, knowledge, familiarity with the company. I don't know whether even the whole managing director would be having on continuous basis what is expected of an independent director. Seek appropriate clarification, amplification of information where necessary. Take and follow appropriate professional advice, opinion of outside experts, of course at the expense of the company. Strive to attend all board meetings, participate constructively, strive to attend all general meetings. Keep themselves well informed about the company and external environment. Pay sufficient attention to ensure that adequate deliberations are held before approving related party transactions. This is really going to be an issue where independent directors will have to really spend time and use their discretion. Report concern about unethical behavior or actual or suspected fraud, which in any case auditors also have to do, but now independent directors also have to do. So these are some of the aspects so far as the role, responsibilities and duties are concerned. Manner of appointment, it is for a fixed term by the general meeting. So far as resignation, we will go to it separately, and the other three aspects we will take it up separately. Now, reappointment of an independent director will be based on evaluation. All the directors, independent directors except the person under evaluation will not attend that meeting, which means first such evaluation will come across only will be perhaps 4 years down the line, 4.5 years, because currently all are being appointed for a period of up to 5 years, that is right up to 2019, and in 2019 for the first time perhaps this evaluation will take place based on which. Now there are no guidelines for this, perhaps the institutes may come out with some guidelines, but broadly it would be whether he or she has been attending the meeting, actual participation in the meeting, the kind of contribution to those discussions, any suggestions, etc., to indicate that particular person, how deeply he has been interested in his appointment as an independent director. Performance evaluation of independent directors to be done by the board, as I just said. Now this is another one, what is expected. Training of independent directors. The law expects, particularly SEBI wants that all the independent directors should undergo training. To an extent, it does make sense because there are people who are not at all connected with the corporate board's functioning. They come from fields where they have nothing to do with the boards. They have no idea. They are appointed as independent director, but they don't know what is expected of them. They don't know what are their rights and responsibilities. They don't know what are their obligations and risks they are involving by becoming independent director on the board. They don't know how to seek information from the board. They don't know what role they are expected, except that they know that they will be independent director on the board. So, to an extent that yes, it is very important that independent directors do undergo training. Now it is through the committees, apart from the board, we will find the role of independent directors. And that will be these two committees, audit committee, nomination and remuneration committee, particularly the audit committee. And more so in the context of related party transactions. Related party transaction, an audit committee, every company having a paid-up capital of 10 crore or more, or 100 crore turnover, or 50 crores borrowings, has to have listed companies, so of course they have to have, there is no exemption for them. Related party transactions. Now here again, if you see, under section 188, third proviso to subsection 1, clearly says that if the contract or transaction is in its ordinary course of business and an arm's length transaction, then subsection 1 itself is not applicable. And subsection 1, what does it say? It starts with subject to approval of the board. So even the board approval is not required. But what does SEBI say? SEBI says all related party transactions should have prior approval of the audit committee. Now there one can say, but here the Act says that you are exempted. That could be applicable to any company. But if you are a listed company, you are also guided by SEBI, and remember SEBI regulations are in addition to the Companies Act and not in abrogation of. They are not, or just that Companies Act will prevail. No. It is SEBI in addition to, and wherever it has to prevail, then SEBI will prevail, or when possible, concurrently both compliances will have to be done. So a listed company has no option but to, and SEBI will always be more stricter norms because Companies Act is across the board for all the companies or public companies wherever applicable to private companies, whereas SEBI obviously exclusively for listed companies, and therefore the safest way for a listed company would be all related party transactions to be routed through the audit committee, an audit committee to the board, and then companies which are falling in the category as presently the norm is if the paid-up capital is 10 crores or more, or the size of the contract is more than the specified quantitative norms, 10% or more than the net asset value or net worth, etc. 4 or 5 norms and the rules are given, then in that case prior approval of the shareholders is required, prior approval of board is required. So therefore in that case, to be on the safer side, now the issue may arise that how do we know in the beginning of the year what kind of contracts you will be entering into? Then in that case, you may have to go for postal ballot or whatever. But here, slight anomaly, let me point out your attention to this, although it's not directly in this, but at the same time related. Under subsection 1, first proviso of section 188, related party transaction, it talks of prior approval if you have the prescribed capital or prescribed quantitative norms you are crossing, then you require prior approval. But if you go to subsection 3 of same section 188, there it will say you should have got it ratified within a period of 3 months if you are not already done. So what it implies is very clear that if there is no prior approval, at least within 3 months you should have got the contract or transaction approved. And what are the consequences if you have not got it approved? It is only voidable at the option of the company. Now this could have been in a simple way put in first section itself, subsection, that preferably within a period of prior approval, preferably prior approval, or in any case within a period of 3 months to be ratified. Instead, when you read in isolation one section, subsection, it gives you the impression that it is must in every situation prior approval is required. But when you read subsection 3, it clearly says ratification is also permitted, because in business it will not always be possible to take advance approvals or prior approval, and therefore this kind of ratification also could be permitted. But it will be important that enough information is supplied to the audit committee, where in any case the majority has to be independent directors, and therefore independent directors will be having the biggest responsibility under the audit committee, because they will be clearing all the related party transactions, and it will be in the interest of the company itself, as also the independent directors provide maximum information, relevant documents, relevant papers, and let the minutes of the audit committee as also of the board where these related party transactions are noted be speaking minutes.